Hi guys, Alina Shaltsova, immigration attorney from Brooklyn, New York is here. And today we're going to discuss the most recent immigration news. I'm going to talk about the important case that is currently being considered by the United States Supreme Court involving executive powers or whether or not DHS may set policies that control the way the immigration enforcement is being done in the United States. And of course, in the end, I'm going to answer you guys' questions. So please comment with your questions, say hello, let me know where you're watching from. Very important, let me know if you can hear me, because once a couple of weeks ago I did live and I was talking for 3 minutes before people let me know that they could not hear me. So thank you very much for joining again. My name is Alina Shaltsova. I'm an immigration lawyer, practicing immigration lawyer from New York. I help clients in New York, all 50 states in the United States, and of course, people overseas, those who need United States immigration help. We help with a variety of cases: removal, asylum, immigration waivers, family petitions, employment petitions. So if you have your questions, please let us know how we can help you. You can reach me at 917-885-2261. And of course, visit our website for free in immigration information and updates on the most recent immigration news and tips on how different cases are being processed. So thank you guys. Hi Nick, hi Sunil, thank you very much for joining. And let's start. Well, the first thing I wanted to talk to you about is this interesting news that actually today Supreme Court of the United States was hearing oral arguments in a case United States versus Texas. This case involves dispute over whether or not DHS, Department of Homeland Security, has a right to set enforcement priorities. If you recall, last year, a new Secretary of Department of Homeland Security issued an enforcement priorities memo saying that ICE has to focus on certain groups of population, on non-citizens, and leave alone other groups. So basically, if you were not presenting risk to public safety, you didn't have some heavy criminal conviction, you did not present risk to national security, you would not be deported. In other words, right? ICE would not start the enforcement against you, or if they did, they would stop the enforcement against you. So guess what? Some states did not like it, like Texas. And the United States government was sued in court. Lower courts went back and forth. Eventually, a federal judge ordered the immigration enforcement priority to stop. The lower federal court stated that it was not right for the Department of Homeland Security to change the way immigration law is going to be enforced. And of course, now, United States Supreme Court is going to give the answer whether or not executive branch has this discretion to how immigration laws to decide how immigration laws should be implemented. Another important question is this: whether or not states have any saying in what's happening with federal enforcement of federal immigration laws. So now, of course, we do not have decision yet in this case. We're waiting to see what the decision is going to be, but it's an important, very important case for immigrants. Why? Because it challenges the core as to how the laws are being enforced, and if executive branch has discretion in enforcement of the laws. If they don't have discretion, then basically the government has to strictly follow the law that's written without any consideration to factors, individual factors that the person may present. And I don't think it's right, because we have bodies of cases that confirmed time after time that in fact prosecutors, ICE, have discretion that no one can take from them to decide what they want to do in each specific case. So I think the court is going to rule this way, but of course, you never know what the Supreme Court is going to decide, and we're going to wait for their decision. And of course, I will give you my updates. It's very important for those of you guys who are in immigration court, who are waiting for the asylum interview, excuse me, or who may end up in immigration court, to know, right? To know what exactly is going to happen, how to argue prosecutorial discretion in your particular case. So we're going to watch and going to see. So that's the update I wanted to share with you guys. And now I'll be happy to answer some of you guys' questions. Again, don't forget to let me know where you are watching from. Say hello, and let's start with your guys' questions. All right. Hi, Sid. Hi, Sunil. Thank you very much. Hi, Lucky. Hi, Kamran. Hi, Isaac. Hi, Nick. Hi, YouTube Gold Play Button. That's nice. Nice name. Good mornings. I know some of you guys have morning and some of you guys already have afternoon. All right. Hi, Paul. Hi, how much can a European citizen have in the United States bank to obtain an investment visa, and what will be the duration of the visa? Very good question. There are actually a couple of investment visas that a citizen of European Union, any of the countries, may consider. One of such visas would be E2, non-immigrant investment visa. The visa does not let you to get the green card directly, but allows you to obtain status in the United States indefinitely if your petition is granted. What's good about this particular visa is that there is no set amount as to how much money you need to invest. All the law is saying is that the investment have to be significant. What significant investment is determined in each and particular case. So that's one of the ways to stay in the United States or come to the United States. Another way would be to apply for a green card-based investment, or EB-5. And here we're talking about significant amounts of money. I believe it's over $1 million. So if you do have such money, I suggest that you have a consultation with an attorney to go over the requirements. But here, what you need to know, even if your petition is approved, you're going to get a green card. But first, the green card is going to be on conditional basis, issued to you only for 2 years. All right. And then you have to demonstrate that you do have the investment, that you fully invested into the enterprise, and your enterprise is working, and your enterprise is a real enterprise, and so on and so forth. So it can be burdensome for some people, but again, it depends on how much money a person has. For some people, $1 million is a lot of money, and for other people, it's just a tiny bit that they are eager to invest in order to receive status in the United States. So it depends. But for most people, I would suggest to look into E2 visa, which is much more affordable and still gives you an opportunity to come and live with your family in the United States. Hi, Alia. Hello. Can a undocumented who is in removal proceedings marry someone undocumented who is applying for asylum in the United with USCIS? She can add his spouse to asylum application. Surely the person can be added to the asylum application, but you have to know one thing. If undocumented person, one of the spouses, already in removal proceedings, their removal proceedings are not going to be stopped automatically only because the person was added to someone else's asylum application. It's extremely important to remember that. However, you may argue that maybe your proceedings should be administratively closed, at least pending resolution of the spouse's asylum case. That may be an option, right? Maybe even terminated. It depends on what prosecutor and judge will agree to do in your particular case. So it's a good question, but you have to remember also that once the cases of spouses are separated, they're not going to be automatically united. So your lawyer will have to do something about this, all right? That's what you need to know. And there is a difference between a pending relief and relief that was already granted. So it's another important factor, especially now when powers of prosecutorial discretion are being challenged. You have to really, to have your best arguments, you have to follow the law very strictly to show that, for example, you do have a relief, right, available to you. So they have to close your case. So just keep those points in mind. Hi, John. What are the options for someone with a pending asylum case to get a green card? Well, it depends. Sometimes there are not so many options, and sometimes there can be options depending on the person's situation. Of course, if the person has legal entry to begin with and now has an immediate relative in the United States, for example, a spouse, a US citizen spouse, then they may be able to adjust status based on marriage rather than pursue the asylum case. Some people can benefit from employer sponsoring them, but it's in a very narrow set of circumstances. Most people will not be able to, but some people can. U visa may be an option, right? Or T visa may be an option. But that's what I would say to start your research in those 4 directions to begin with. One thing I wanted to share with you guys, which is very important for those who also have TPS or can qualify for TPS, temporary protected status. July memo, recent memo says that if you receive TPS status, travel outside of the United States on advanced parole that you receive based on TPS status, and come back to the United States, all your prior illegal time, unlawful presence time, will be erased, and you will be able to get employment-based adjustment of status. Extremely important. I think I had the discussions before, and prior to me absolutely being sure that this is the case, I did not want to share this information, not to give you guys any sort of misrepresentation, but now you know. So consider this situation. Let's say you're from Ukraine or Afghanistan, countries that were recently designated for TPS. Or maybe you're from El Salvador, country that was designated for TPS a long time ago. You received your TPS status and you traveled on advanced parole outside of the United States and came back. Now you're considered to be legal for the purposes of adjustment of status based on employer's petition. It's extremely important to know that, and some of you can benefit from this information. Okay, let's next question. Hi, Paul. I'm an Austrian citizen and have 3 months visa free to the United States. Okay, so visa waiver, guys. Visa waiver. If you come to the United States on the visa waiver, you will not be able to change the visa waiver to any other status, apart perhaps if you marry a US citizen. All right, it's very important to know. So if you have some other plans, if you're planning on staying in the United States, working, do not come on the visa waiver. It's not going to work. Hi, DJ. DJ, can I switch I-130 petition to TPS case? You can't really switch, but you can file for TPS if you qualify. I-130 case, I-130 is a petition for an alien relative. By itself, it doesn't give a status to the non-citizen. It's very important to know that. It only can serve as grounds for the status. Sometimes you can file for the green card at the same time when you file I-130 or I-130 is being filed. On other occasions, I-130 has to be approved first, and then a person has to receive a visa overseas. But TPS is different. TPS, or temporary protected status, is given to those people who are nationals of certain countries that were designated for TPS. For TPS, it doesn't matter if you have a relative in the United States or not. All that matters is that, first, you're a person of good moral character, and you reside in the United States on a certain date. That's all that matters. TPS can be given to those who already have orders of removal against them, who overstayed their status, maybe who never had status. So TPS, of course, is a good option for many. And in the light of what I shared with you previously, that TPS can be a good way for somebody to get back into status and to get employment-based green card. I absolutely think that anyone who qualifies for TPS should be applying for it. All right. Hi, Ram. I have a removal order 2001. My BIA denied motion to reopen was denied 2005. I'm married to a United States citizen. Can I reopen my case without any problem? I have no criminal record. Can you try to file to reopen your case? Yes. Will it be without any problem? I cannot guarantee you that. So it's true that even if you have an old order of removal, you can file a motion, sua sponte motion, to reopen your case if now you have grounds to fix your status. You will have to show your plan as to how you're going to be fixing your status if your removal order is reopened. So a week ago or so, I shared news with you that Attorney General issued a decision advising courts that they should exercise their discretion in certain situations, helping non-citizens to fix their immigration status. If we're going to use that decision, I think it's going to be a good time for all of you guys who would like to file those sua sponte motions to reopen to try to do this now before perhaps administration changes and try to fix your status if you have a good plan. For example, now you're married to a US citizen and you can show that a long time ago you entered the United States legally. You're a perfect candidate now for adjustment of status. But remember, to file your motion to reopen based on that, your spouse first has to file I-130 petition and it must be approved. Okay, so it's going to take some time. But can you try? You absolutely can, and you should try. And you should try. Hi, Equity Justice. When will we know if the Supreme Court will cancel DACA? Do you think Congress will pass pathway for citizenship for DACA during lame duck session? Do I think they will pass? I hope they will. If you recall the history of this DACA situation, you will know that there was time when Republicans wanted to pass law for DACA recipients. So we certainly have hope, but will it happen? Guys, I really do not know. Some lawyers say that they do not believe anything can happen. Well, I do not know. Why? Because they don't really give us current updates as to what's happening. We receive bits and pieces of information, and based on the information we receive right now, it doesn't seem likely. But again, we do not know what these two sides are negotiating. Usually, something like this, litigation that will help immigrants, will be a result of some political game where one side is going to compromise with another side in exchange for something else. Is it possible? I think it is. But will it happen? I don't know. I don't know. When will we know the decision? I'm not sure. Also, maybe in December, maybe not. I do not know. It depends on, usually, it takes a Supreme Court several months to issue a decision. So can't tell you really. I'm curious as to what's going to happen. If you ask me, I think that executive branch has powers to say how the laws should be implemented. Whether or not DACA will be upheld depends on how we see DACA. Is DACA simply a regulation that tells us how to treat certain people, or did it create a new status? Did it create a new status? So if the Supreme Court takes a position that DACA was a new status for certain people, then I think they're going to take it down. But if they agree that DACA was simply a new way to regulate an old problem, then I think DACA as executive action will be upheld. So we're going to see. Highly wise man. Can someone who trying to reopen motion can get married to get a green card? To get married to get a green card. All right, so you can't get married just to get a green card. But if you are thinking about motion to reopen and you're marrying somebody and you know you can adjust status apart from the order of removal issue, then you certainly can try to file motion to reopen. And remember, marriage will be considered good marriage for immigration purposes only if it's a real marriage and not done to avoid immigration laws. Very important. Aha, so we have more information. My asylum case got denied twice. Can I get married to a US citizen? You always can get married to a US citizen. It has nothing to do with your asylum case. But whether or not you will be able to benefit also immigration-wise from that marriage, of course, depends on, number one, if the US citizen petition for you will be approved. I-130 petition must be approved. And second, if your motion to reopen will be successful. Perhaps you also can choose, you will choose to waiver route. Guys, sometimes you file a motion to reopen, but it's not being granted. So you can choose another route. For some people, it's going to work. It's when you file two waivers. The first waiver, I-212 waiver, is filed with DHS, ICE, and if it's granted, it's going to waive bar for you to come back to the United States because of your removal order. You may know that if you have a removal order, usually you cannot come back to the United States for 10 years if you leave the United States. But there is a waiver for this. So this is waiver we just discussed, I-212 waiver. If that waiver is approved, you also will be able to file for I-601A waiver that is going to waive another ground of inadmissibility, unlawful presence time. So for many people, it's going to work also. But of course, motion to reopen is more desirable because then you don't have to travel overseas to get your status. See the difference? If you file for waivers, you have to leave the United States. Many people do not want to do that for a good reason. They have concerns that they will not be able to come back. So it's important to maybe sit down with an attorney and see which route is better for you, okay? Because a lawyer, experienced lawyer, will be able to tell you usually what you should try first. Hi, think positive. How long need to wait for I-45 asylum if case was transferred from Texas Center to National Benefit Center? Will really not be able to tell you. I'm so sorry. It seems that National Benefit Center usually grants or decides cases that are pretty straightforward. So I know that the processing times for green cards based on asylum can be as long as 24 months. Hopefully, it's not going to be your case. But if your case is pending beyond processing times, I suggest that you file a congressional inquiry. Even if you're not a citizen in the United States, you have a right to contact a local congressman and ask them for help with your immigration case. And guys, it's very effective and it's working. So I suggest that you do that. All right, and I'm going to take the last question for tonight. Hi, Thomas. I'm in removal proceedings. Judge can decide for my marriage case. Can now judge terminate my removal proceedings so I can adjust status with USCIS? I heard judges now can terminate cases. Absolutely, Thomas. Now it's going to be a good time to ask that your case is being terminated. If you can show that you can adjust status with USCIS, it's a good time. This practice was a routine. It was done ABC 1, 2, 3 before Trump administration came to office. After Trump administration took over, this practice of terminating cases stopped. And a non-citizen was forced to stay in immigration court to wait for the resolution of their immigration case. But now, again, I'm going to go back to the decision by Attorney General that was issued recently. You will be able to ask the court to terminate the case if you can demonstrate that you have a chance of fixing your immigration status with USCIS. So absolutely go for it. Well, guys, thank you very much for watching, for joining. Please like, share this video, help me to grow my channels, Facebook page and YouTube. And don't forget to join next week for another live. Hopefully everything will be good and I'm going to be here another Tuesday. Again, thank you very much for watching and joining, and I hope to see you